Okay, good morning.
Good morning.
Good morning.
Okay. Um, Thank you for being here. Pleased to be joined on the panel by Judges Wallace and Sasso. You each have 20 minutes for oral argument. You should have a clock on your screen. Can you see that?
Yes, Your Honor.
Okay. And if you want me to help you keep track of time, Appellant's counsel can let me know how much time they wish to reserve for rebuttal. And I also want to advise you that these arguments are being live streamed so that the public has a chance to observe them. With that, Appellant's counsel may proceed.
Thank you, Your Honor. May it please the court, counsel. My name is Rachel Reese, and I represent the appellant in this matter, Charles Murillo. I would like to reserve 5 minutes of time for rebuttal.
Okay.
I would like to focus our argument today on the issue that was raised in ground one of Mr. Murillo's initial brief, which focused on the trial court's error in denying his motion for judgment of acquittal as it relates to several of the counts charged by the state of Florida. Mr. Murillo, in October of 2016, was seen walking towards a vehicle that was later pulled over by law enforcement. And as a result of that traffic stop, he was later arrested 2 months after the fact. Now, the state's witnesses at trial alleged that Mr. Murillo was seen leaving an apartment with a black bag on his person. He then entered the vehicle in the front passenger seat, and the vehicle then drove for approximately 2 miles where law enforcement could not see inside the vehicle before the traffic stop began. After the stop took place, during the traffic stop, the bag was questioned about who it belonged to, along with Mr. Murillo and the 3 other passengers in the vehicle. And when all of the individuals inside the vehicle denied any ownership, the owner of the vehicle and the driver of the vehicle ultimately gave law enforcement permission or consent to seize the bag. After searching the contents of the bag at another location later on, it was determined that there were several illegal items in there, including containers that had cannabis, fentanyl, and heroin, along with paraphernalia as well. Now, it's our position that this court should find that the trial court erred in failing to grant Mr. Murillo's motion because the state failed to prove beyond a reasonable doubt that Mr. Murillo was guilty of trafficking in heroin, possession of fentanyl, possession of cannabis, and possession of paraphernalia, because all of those counts relate back to whether or not Mr. Murillo had possession of this black bag where all of those were found. And it's our position that the evidence presented does not establish that he did have possession of that bag.
Ms. Reese, the bag was observed, I believe the officer's testimony was it was observed in Mr. Murillo's possession prior to entering the car, or a black bag, correct?
Yes, Your Honor.
And was there any evidence ever in the record that that black bag was close to anyone else based upon the officer's observance such that it would be under their control?
That's an interesting question because there was no testimony that the bag was ever obviously within, underneath someone else's seat. It's undisputed that the bag was found under Mr. Murillo's seat. It was, I believe, tucked halfway underneath his chair in the front passenger seat. So I don't think that there's any dispute in the evidence in that. So there's no evidence that anybody else was ever seen with it. However, there was it's our position that there was a dispute, or at least an issue, as to whether or not the black bag seen by Mr. Murillo was still the same bag that was later found in the car, because of the fact that law enforcement, number one, there was a 2 mile period of time where Mr. Murillo and the other occupants of the vehicle could not be seen. And when they were eventually pulled over, the officers testified that they were not able to search the vehicle because they didn't have consent and they didn't have any other reasons to search it. So they were not able to decide if there was any other bags in the vehicle that could have also been that black bag. So it is our position that they inferred it was the same black bag and did not actually know that. It's not like this was a unique bag that had some sort of insignia on it that would make it stand out. It was simply just a black, plain duffel bag.
Let me ask you this. Was there testimony from one of the officers that they did not observe any other black bags in the car?
The testimony from the officers was that they could not say if there was any other bags in the car because they had not searched the rest of the vehicle. So and I believe we cited this in our reply brief. The transcripts on page 67, it says that neither of the officers, because they did not search the entire vehicle, they could not say whether or not there was any other black bag. So I think that's an issue that is important to Mr. Murillo's position, is that it is just as likely that there could have been another black bag because they did not have a reason to search the whole vehicle. This is not a case where they searched the whole vehicle and found what was close to every other passenger. We're basing this all off of one bag that's been seen with nothing else. And I think it's also important to note that this bag was not readily apparent to law enforcement as contraband because they obviously needed consent to seize it. If it had been something that from its face they believed probable cause to seize it as something that was illegal, then they would have done that. And instead they were forced to try to get consent from the passengers. And then when they all denied ownership, ultimately the driver was the one who gave permission or consent to actually take the bag, but they would not let them search the vehicle.
Did one of the officers testify as the same bag?
They did.
Okay, and I assume they were cross-examined on that point.
They were, Your Honor, extensively.
And was there testimony that officers were at each side of the car so that they could observe from both sides of the car at some time or another?
There was a video that was introduced, but it was not anything that would have represented that. And there was not a lot of testimony about the specifics about who was of where things were placed inside the vehicle. It was more of the bag was in the front seat. The main focus was trying to seize the bag and trying to get permission. There was no testimony about where anything else in the vehicle was or what they could observe from plain view. And I think that also supports Mr. Murillo's position. And I think that the other thing that Your Honor mentioned about the officer saying that this was the bag is that the issue for us, and it's our position about actual possession, is it's at the time that the bag was seized or at the time that it was taken. And the bag was not in Mr. Murillo's actual possession at the time it was taken. It was in a jointly occupied vehicle within reach of several individuals. And that is why our position still is that the state was required to prove that he was in constructive possession because it was a jointly occupied vehicle. Now,
Ms. Reese, I'm sorry, go ahead, Judge Sasso, go ahead.
I'm trying to figure out if we apply that rule moving forward, that the state would have had to prove constructive possession here as opposed to actual possession because there's other people in the vehicle. Is that any time that there's property in the vehicle that other people can access? Is that when that rule would apply? Or what about this case makes it unique to that rule?
Not necessarily. So there have been cases out there, and one of the ones that is cited, I believe in our brief and the state's brief, is the Gartrell case, which is from 1993, the Florida Supreme Court. That's a case where the passenger admittedly was somebody in a vehicle. It was jointly occupied, but she had a purse. It was physically on her arm, used as a pillow. When law enforcement pulled up, and they found that she was solely in actual possession of that, even though there were other individuals in the vehicle. The issue with the jointly occupied, our position is that because there were other individuals and Mr. Murillo did not have it on his person, it was underneath his seat. The other cases that we cited, the Rangel case and the Culver case, those cases are all very similar because those are instances where the bag is in ready reach. It's proximate to the defendant and proximate to Mr. Murillo. We're not disputing that, but it's whether or not he could have had control, whether the driver could have had control, whether the passengers in the back could have had control. And all of those cases establish that that's when constructive possession, that test needs to be applied.
Ms. Reese, the facts of the case also include that nobody in the car, including Mr. Murillo, admitted to, it was their bag. Everybody denied or backed off. And so the cases that you were citing, do any of them square up with the facts that we have in this case where Mr. Murillo was observed with the bag entering the car, and when the car is stopped, you have four total occupants of the car, the bag is directly underneath him, and you have all four occupants denying knowledge and or ownership of the bag?
Your Honor, I think the most closely related case is the Sanders case that we cited, which is from the second DCA from 2017. And in that case, the defendant was seen walking up to the vehicle with the bag. There was 4 other individuals in the vehicle. There was The bag was found directly next to his seat, and they ultimately found that they had not established that he was constructively possessing the bag because of the other individuals in the car. But there was also an issue with whether or not, their argument was that they couldn't conclusively say that the bag that he had been seen carrying from the apartment to the van, very similar to our case, was the same bag, because they did search the entire vehicle because they had drug dogs that came, and they found other bags. So they could not say conclusively whether it was one bag or the other. So I think that's important in this case because there was no search. So we are in a position where we're just assuming, without the state actually proving, that this is the only bag, when it is just as likely that there are other bags in the vehicle. So I think that the Sanders case is the most similar. And in that situation, all of the occupants, nobody made any incriminating statements. People know there was nothing to that sort. And in this situation, we have no incriminating statements. We have everybody denying it. And we also have a driver that ultimately was able to give consent, which infers some sort of possessory interest. And then we also have another witness that's come forward that is saying that this bag belonged to him and that he left this bag the day before, and is claiming ownership of it, and explaining why there is evidence linking Mr. Murillo to it inside. So I think that all those collectively help distinguish the case from the Sanders case, but also it is similar enough that this court hopefully will find that should come to the same resolution.
And did the trial judge address the credibility, or what was perceived to be the credibility of the witness who came forward a day later as far as admitting ownership of the bag?
The credibility of the witness, I believe, was addressed at some point by the court, not during the actual trial, but in some preliminary matters that were brought up. And again, I think the record speaks for itself about this individual with the prior convictions and things of that nature. And obviously, at this juncture, the circumstantial evidence standard of review is not applicable anymore. All of that aside, our position is still that looking at that testimony and the cumulative evidence that was presented, the state a rational trier of fact could not find beyond a reasonable doubt that, including his testimony and the state's evidence, that Mr. Murillo was in possession of this either constructively or actually. And so that is where our position lies with that. Our position is that that witness provided additional reasonable doubt that the state was not able to rebut or refute through their evidence, because their evidence was lacking to begin with. One moment. Now, the other thing that the state obviously relied upon is the fact that there was a fingerprint on one of the bags inside the black bag, and that is undisputed. Can't get away from that. And that was relied on very heavily by the state, obviously, to support the cannabis charge, because it was the bag of cannabis was inside another bag, and that outer bag was the bag that actually had Mr. Murillo's fingerprint on it. And that was a little bit confusing from the record. Now, one of the examples that counsel gave at the judgment of acquittal argument, which I think is instructive and kind of important at this juncture, is he argued that finding that because one fingerprint is on one bag means that Mr. Murillo has knowledge and control over the entire bag and its contents would be the same as saying that a passenger in a vehicle who has taken ownership of one suitcase is responsible for everything in that vehicle. It's not the same thing. By finding that one fingerprint, that the state cannot say when that was put on there, whether it was put on there before the cannabis was put in the other bag inside of it, they can't establish that. So the position is that even viewing the evidence light most favorable to the state, looking at all the charges independently, the evidence is not enough for at least the heroin charge, which is the most consequential charge, that the fingerprint on the other bag does not establish that Mr. Murillo had possessory interest or had control over the entire bag and the entire contents of it. So I think that example that was given at the judgment of acquittal is instructive here and is important, because that one fingerprint was used by the state to argue that he had knowledge of all the contents in the bag, which our position is that it does not.
Was the evidence that there were no other usable fingerprints on any of the bags other than this one?
There were 9 total fingerprints, but the other 8, they were usable, but they could not rule out or conclude that Mr. Murillo was any of them.
Right. So they couldn't say that one of these other fingerprints was from another individual.
Correct. And they never tested them against anybody else. They never tested them against the individuals in the vehicle or Mr. Lewis that came forward and said that the bag was his. And that was one of the arguments that counsel made also, is that that could have corroborated everything. And that was never done in this situation, which again supports the reasonable doubt aspect of this, that there were other potential suspects that were never looked into. Now, the state's case against Mr. Murillo, again, came down to whether or not he was in possession of this black bag and the items within it. It's our position that neither actual possession or constructive possession were proven beyond a reasonable doubt, and a rational trier of fact could not have found that beyond a reasonable doubt. And so we're asking this court to find that the trial court erred and vacate Mr. Murillo's counts 1 through 4 accordingly. Thank you.
Thank you. Okay. Not sure where. There we go. Appellee's counsel returning to the picture.
Thank you, Your Honor. May it please the court, my name is Richard Pallas. I represent the state of Florida. It's the state's position that the trial court properly denied all 3 of these motions. Going off the judgment of acquittal, it's important that we view all of this evidence, and the fact that the standard is that we view this evidence in the light most favorable to the state.
Is the state arguing that you proved actual possession, constructive possession, or both?
Well, Your Honor, I believe actual possession is what the state is mostly focusing on in its argument, specifically because the defendant was seen carrying this bag. Both officers testified that was the same bag. He was not only seen leaving his apartment with it, but entered the driver's vehicle with it as well. It was found at his feet. Even though he disclaimed ownership, after they took the bag, his fingerprint was found within it, on only the bag containing the cannabis. So it's the state's position that because he was actually seen holding this bag in the light most favorable to the state, the JOA should have been, was properly denied. Specifically because with some of Appellant's case law, specifically the Wrangle case, I know that both cases cited by us are distinguishable in different ways. The state's reliance on Bedford necessarily doesn't explain whether there were multiple people in the car. It's important to the state that in that particular case, the defendant was seen specifically with the container that eventually contained the cannabis or the illicit substance from there. In the Wrangle case, of course, all 3 occupants of the vehicle were seen selling the crack cocaine to the confidential informant for the hand-to-hand. And afterwards, when they were pulled over, the defendant was in a different part of the car, and they didn't find that same drug. They found, even though he was fishing his hand around the area where it was eventually found, no one actually testified to him holding that container that had a different type of illicit substance. I can't remember the exact isomer or however the court defined it, but that defendant in Wrangle was not seen actually holding the container, which of course in our case, again, this defendant was seen holding this container, getting in the car with this container. He was pulled over very, very soon after they left the area. It's the state's position that this evidence is enough to prove for a reasonable jury or a reasonable fact finder to find that actual possession was proven for all of these narcotics that were found.
How would you distinguish this case from the Sanders case that Appellant mentioned?
Oh, I apologize, Your Honor. I couldn't hear you. Let me try to turn up my volume of these speakers here.
You don't hear me now?
I apologize. It's still breaking up a bit.
The judge asked, how would you distinguish this case from the Sanders case relied by opposing counsel?
Oh, thank you, Your Honor. Just to be certain, you meant the Sanders v. State case? Yes. Sorry about that, Your Honor. In the Sanders case, the state can distinguish that because there was a white male observed entering the van. And when they got into the van, there were multiple white males inside of it, including the defendant, Sanders, in that case. Sanders was next to two bags. The white male entering that van was only observed holding one. And no one, I believe, was able to positively identify Sanders as the person holding the exact bag that was seen. And also importantly, in Sanders, there were two bags. In this case, we have no testimony that there were multiple bags. In fact, most of the cross-examination that I noted regarding whether or not there's another bag in this vehicle was saying, you don't know if there were other things in the car besides that, right? Referring to the first black bag. The officer, I believe this was Officer Fabian, stating, I don't know. And then defense counsel repeating, you can't say whether there was more than one bag in the car. I can't. This doesn't confirm that there's multiple bags in the car. What's important is this, again, we're taking light most favorable to the state. And this isn't a case of Schrodinger's bag in a Lexus. If we had maybe some evidence of these bags being in here, then perhaps there's more of an issue. But we have testimony of two officers saying that's the same bag, both of them.
What about Mr. Paulus, what about the lack of fingerprints on any of the other contents of the bag?
Yes, Your Honor. It is noted that the fingerprint is on only the bag of cannabis, and all the other fingerprints were, I guess you'd say, inconclusive to whether they could be found similar to the defendant or anyone else. But while, of course, that doesn't necessarily help the state with everything in there, the fact that all these items were found in that same bag and the appellant was observed carrying that bag and the bag was found at his feet, that the state believes is enough to prove that this was his, even among his repeated denials and the witness brought on in the defense's case in chief claiming to take credit for this treasure trove of narcotics found within the bag. Actually, I don't recall from the record whether the video itself of the stop was admitted. That might be more for the motion to suppress, but all the windows are open in that particular video. I know the state did not cite to any specific points of that, but for most of that case, everyone's being addressed. Of course, there's always the possibility of bags under someone's feet or sitting under it, but they saw this person clutching a satchel or duffel bag, depending on what your definition of a bag would be, and it was found at his feet. But if your honors don't have any other questions regarding this case, the state obviously asked that it'll rely on its brief, and I ask that you affirm.
Okay. Any other questions from the panel? All right, thank you. Rebuttal.
Thank you, your honors.
Please.
Thank you, Your Honor. Just briefly, a few points. The first point I wanted to mention is that the state identifies that there was a very, very brief period of time where the vehicle was driving before the traffic stop. Pursuant to the testimony of the main officer, it was 2 miles, over 20 blocks, where he admitted that he could not see what was happening in the car. And I think that's important. I think the other aspect that's important that's kind of been established here today is that this is kind of a hybrid case. This is not like a lot of the other cases that have been discussed in Florida. This is a case where it's not just a traffic stop where they had no idea who was going to be in the vehicle, or something where they saw a person by themselves. It's kind of a hybrid of that, because they're alleging that they saw somebody walk up to a vehicle, get in the vehicle, and then they were later pulled over, not knowing that there were so many people in the vehicle and didn't have enough to search it. So they're stuck with just the inference of trying to get this one bag for whatever reason. And I think that is important for the court to take into consideration, is that we have to look at this in a hybrid way. And I think looking at it like that, the constructive possession is the more ruling scenario to look at with the situation, especially in light of the timeline and things of that nature. And again, I think it's important to highlight, and I don't know if it was highlighted as much at the trial court level, the fact that the officer could not take this bag until it received permission from someone shows the complete lack of.
Ms. Reese, there was testimony that at the time the defendant was arrested, he was at his apartment, wouldn't let the police in, and then they found cash, a lot of cash and drug paraphernalia. Could the jury consider that as possible consciousness of guilt?
They absolutely could. However, I believe that they did not, because the jury ultimately found Mr. Murillo not guilty of one of those counts. I believe it was the paraphernalia count. And so I think that's important, because obviously the state asked them to consider that as kind of collectively with the incident 2 months earlier, and they chose to reject that. And obviously, I think with the issue with the officer, of course, they can consider that an issue with guilt. But at the same time, I believe that because of the length of time in between the two incidents, I don't think that that's very persuasive. And I think that the jury would have found similarly based on the other evidence in the record. If your honors don't have any other questions from myself, I would just ask the court to grant the appellant's or reverse the appellant's case with directions to vacate counts 1, 2, 3, and 4. Thank you.
Thank you both for your arguments. Excuse me, and we'll be in recess till 10 o'clock.
Thank you.